Hello and welcome to this short piece on interim injunctions. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. An interim injunction is a temporary injunction. It's an order prohibiting the respondent to the application until the hearing of the case or until further order from doing or refusing to do something, and it's backed up with the powers of the court, which can include imprisonment for contempt of court. It can be granted at any time during proceedings or even before the claim is issued. We're going to look at the civil procedure rules, and in particular Rule 25 and 23 later on. But for the moment I'd like to deal with the basic guidelines which derive from a case called American Cyanamid Company. These are the following. The court's going to ask itself whether there's a serious question to be tried, and the claimant must show a real prospect of success. The court will ask whether damages are going to be an adequate remedy as opposed to ordering the respondent to do something or refrain from it. If damages are not an adequate remedy, so that the court, if it's going to do anything, will need to do something real, the court asks itself whether the balance of convenience is in favour of granting the injunction. Does the defendant have an arguable defence? If so, the judge will weigh the balance of convenience of granting an injunction. So that's going to look at the potential harm to the defendant or respondent if the order is made, as against the potential harm to the claimant if the order is refused. The balance of convenience can shift over time, so quite apart from anything else, it's important to be expeditious in seeking the interim injunction in the first place for this reason. If all the other factors are evenly balanced, then the court will seek to preserve the status quo. It may ask itself what the relative strengths of the cases are, but won't examine the merits of the parties' cases in detail, except in those situations where the application for an injunction, interim injunction, is likely to dispose of the proceedings. It's worth looking at some of the features of the hearing of an application for an interim injunction. Normally no oral evidence or cross-examination is allowed. The application will be made at a point where pre-trial disclosure has not been completed, and there may even be no statements from both sides. For these reasons, the court has to apply a different type of scrutiny to the level it provides in a full hearing. It's important to note these distinctions, because very often an interim injunction application will be decisive, especially in an employment case. The interim injunction is a temporary and discretionary remedy, and this has certain consequences. Obviously, the court's going to be using untested and incomplete evidence. This is why they've developed the rule that there must be a serious question to be tried, and it also is the underlying reason for the importance of the undertaking in damages. Secondly, conflicts of evidence are not going to be resolved at this stage of proceedings. They're not going to be resolved on written evidence. Equally, difficult points of law are not going to be decided using this procedure. However, the uncertainty does not prevent an injunction being granted, uncertainty as to fact or law. What it aims to do is to protect the claimant where damages are going to be an inadequate compensation for the damage that's going on in the interim. If damages are an inadequate compensation, then the need of the applicant is weighed against that of the respondent to see where the balance of convenience lies in the question of whether it's just and convenient to issue the injunction. Now, that approach is all very well for injunctions which maintain a situation until trial, but if the practical significance of the application is that one way or the other the outcome of the application will determine the outcome of the whole case, then a different approach is to be required. You can see some remarks on this in the Series 5 software case. So the whole point of an interim injunction is to mitigate the risk of injustice to the applicant during the period before the resolution of the uncertainty between the parties by trial could be reached. The other point to be noticed is that there isn't any rule of law or practice that the judge can't take account of the balance of convenience unless he or she has first been satisfied on evidence from both parties that on the balance of probabilities the acts of the respondent would, if they were committed, violate the person who's claiming the injunction's legal rights. That approach is too technical. What is necessary, of course, is that the court be satisfied that the claim isn't frivolous or vexatious, and that's what's meant by the requirement that there should be a serious question to be tried. If the position is that the material available to the court on the application doesn't disclose any real prospects of success in the claim for a permanent injunction, then the court won't go on to consider the balance of convenience. But if it does disclose such a prospect, then that's when the court will consider the balance and convenience. However, in some, quite a few, interim injunctions cases, effectively the interlocutory or interim application is the only time in reality that the parties are going to engage in any legal context. It's in cases where it's clear that the case simply won't go to trial, then the interim injunction application is going to dispose of the hearing altogether, the trial altogether. Now, this is the case in most restrictive covenant employment cases. In NWL Limited and Woods, Lord Diplock spoke of the way in which, if the application disposes of the proceedings, then the degree of likelihood that the plaintiff, or claimant as they are now, would have succeeded in establishing his right to an injunction if the action had gone to trial is a factor, and it should be brought into the balance by the application judge in weighing the risk that injustice might result from deciding the application one way rather than the other. But even in these cases, it's not a trial of the case. The judge will control the amount of inquiry that will take place. In the context of employment, it's important to note the provisions of Section 2212 of the Trade Union and Labour Relations Consolidation Act 1992, which specifically requires the judge to look at the likelihood of the success of the defence which a trade union may have to the industrial torts in the context of a strike. The period of time to trial is an important factor in determining whether the application for the interim injunction will effectively dispose of the hearing. Have a look at the CEF Holdings case. In the context of employment restrictive covenants, an application will be dispositive only if the trial of the claim is impossible before the end or before the majority of the restrictive covenant period. Otherwise, you apply American Cyanamid principles. It's worth considering what was said in Lawrence David Limited and Ashton at 1989, ICR 123, and David, Lawrence and Ashton 1991, 1 All England Reports 385, by the Court of Appeal, namely that a defendant in these circumstances should seriously consider, when the case first comes before the judge, offering an undertaking until the hearing of the claim, always assuming that a speedy hearing of the claim can then be fixed, and also assuming that the claimant is going to be able to pay any damages on his cross-undertaking as to damages. That may be a better way of dealing with the matter, and it's only if a speedy trial isn't possible that it's going to be necessary to have a decision on the interim application for an injunction.